To continue further, the committee also spent a great deal of amount on research, and the research is one of the key ingredient for providing legal aid, because through research they could look into how these legal aid schemes are working, how the several acts under which the legal aid is now mandatory are working. And for this purpose, the committee says that the authorities are created under the legal services should have a liaison with the law commission and the law ministry at the central level as well as state level. And it also suggests that we should establish a directorate possessing the legal knowledge with the experts in various fields for carrying out this research. Now, while explaining what is the role of the research in this, it says there should be 5 divisions under the research department. The first one is the statistics, second one is socio-economic problems of the indigent and disadvantaged group, third one is litigation research including test case litigation, fourth one is legislative research, fifth one is performance, audit and evaluation. So, these 5 concepts were stressed by the committee, and it says the legal aid organization in each state should have a directorate of research with statisticians, sociologists and a lawyer to assist the director in performance of the 5-fold functions of the research and evaluation outline. That was just now we have discussed. And also it says it is better to develop a common research designs so that it could be effectively used in different parts of the country. And another most important aspect of this committee is legal awareness programs. And keeping in view the amount of illiteracy in the country, and if you actually talk about legal literacy, even many of the literates don't have the legal literacy. Therefore, a great deal of time should be spent on legal awareness programs, educating the people about their rights, their entitlements, their liabilities, etc. For this, the committee has given an elaborate scheme how these legal awareness programs should be conducted both at the national level and also the state level. And it enlists the services and voluntary, it requires a great deal of involvement from the Bar Council. It requires involvement of universities, colleges, teachers, students, social welfare organizations, NGOs in making the public aware about their rights. So, the committee stated that the judiciary must play a very important role in this regard. Further, it says that the state should ensure that the laws that were made by the state must be understandable and available easy to a layperson. So, therefore, it recommended that the Bar Council of India should make rules to call its members to conduct these legal awareness programs periodically. And also it talks about it is an obligation on the part of every legal graduate to join in the bar, spend at least 6 months as an intern in any legal service organization. And any legal graduate joining in such internship should be provided with 250 rupees per month as a honorarium. And only a legal graduate who completes this internship would be entitled to enroll as an advocate. So, the another concern that was raised is if you are going to provide free legal aid, would it result in docket explosion? What I mean by docket explosion is the number of cases that would increase in the courts because you are getting a free legal aid. As you are not going to spend, you may file frivolous cases in the court. There is possibility. There is a reasonable apprehension that the free legal aid may result in numerous litigations in the courts. So, to avoid such kind of thing, again the committee has spent a considerable time and mentions that the person who applies for free legal aid should satisfy 3 tests. That is means test, that means the government is going to fix the ceiling on the income. Only the people who are below that income can entitle for filing asking for a free legal aid. And the second one is the prima facie test. The prima facie test says that when a person, even though qualified under the means test to get a free legal aid, but still the legal service authority which is suggesting that free legal aid should be provided or not should be satisfied that there is a prima facie case for giving free legal aid. That means there is a reasonable case in that. And the third test that propounded by this committee is that a reasonable test. The reasonable test says that the reasonableness of the suit for availing the benefit of free legal aid. That means it is the only way to get the required remedy. So these safeguards will go a long way in reducing the frivolous cases before the court. Further, the committee also says that establish a conciliation cell. Therefore, whoever comes for free legal aid first will undergo to the conciliation proceedings, and if the conciliation proceedings fails, then only that will go to the court. Then, so that would basically would prevent the misuse of legal services programs. And it also talks about the financial assistance for legal aid program, because that is one of the concern for the committee, how best we could get funding for these legal services. It has given a number of options. The first option is the state must provide a specific budget allocation, like how it is providing for other social welfare schemes. Similarly, a legal aid scheme, they should provide a specific budget. Then second one is revise the existing pattern of court fees. And also it says that the court fees must not become a tax on the litigation. So how much the court fee should be charged, it need to have a revision. And it talks about legal aid stamps. A very innovative step that suggested by experts committee is that you create two kinds of legal aid stamps. The legal aid stamps of 1 rupee or 50 paisa, equivalent to 50 paisa, and on every wakalatnama 1 rupee legal aid stamp should be affixed, and for all other you affix 50 paisa legal aid stamp. So this money could be deposited to the legal aid services, and from that money the free legal services could be provided to them. And also it also talks about impose some cess payable on every person. The cess will be for the purpose of getting more funding for the legal services authority. Then the cess should not be imposed more than 100 rupees per case, and also it talks about where the cost was awarded by the court, the cost should go to the legal service authority. Similarly, when there is a property has attached, the property attached, the State Board of Legal Service should be authorized to recover this property or money decreed in favor of legally assisted person, and certain percentage of that could be retained by the board. So if you look at the report is very comprehensive and made several innovative recommendations for implementing the legal aid, and this report became a base for several other initiations taken by the state after 1976. Now, after the recommendation of this committee, the central government has established the Committee for Implementing Legal Aid Scheme. It was established in 1980 and it was established under the chairmanship of P.N. Bhagwati, Judge of Supreme Court of India. The SILAS, in short form, evolved a model scheme for legal aid programs, and the duty was imposed on the chairman to monitor and implement the legal aid programs on a uniform basis in entire India. The SILAS was financed by the central government, and when it was felt that there should be some statutory legal service authority at the national level and the state level and the district level. Therefore, finally, this led to the enactment of Legal Services Authorities Act in 1987. As I discussed in the beginning, though the act was made in 1987, there were certain difficulties in implementing. Therefore, a conference was called to iron out all these problems. The conference was held under the chairmanship of Honorable Chief Justice of India. Justice R.N. Mishra, who was then Executive Chairman of SILAS, moved the motion and made certain discussions at the conference, made a proposal to amending the Act. Consequently, a bill was framed to amend the Act 1987, but for several reasons this bill was not passed in the Parliament. However, in 1987, Act was made enforceable from 1995, and later in 2002 an amendment was made to this Act. So, to conclude today's discussion, the suggestions made by the experts committee played a very important role in giving a shape to the existing legal aid scheme in India, and that is the prime reason how the Legal Service Authorities Act was passed in 1987. Now, the Committee for Implementing Legal Aid Schemes further regulated the uniform implementation of the legal aid program in India. So, both these reports have made what we call as a distant dream of providing free legal aid as a reality today. So, the existing Legal Service Authorities Act is a result of these committees. So, I hope you have learned a great deal about legal aid in post 1976 developments. However, if you have any kind of questions, any further clarifications, we will be happy to help you. Please join in the forum and write to us through emails. We will get back to you and we will provide you further readings. Thank you.